Hello, good evening and welcome to Spotlight. My name is Nwong Falong and you're watching MX24 television, of course. Now, what lies between citizenship and allegiance, and at what point do the grey areas become matters of national concern? Last week, a Cape Coast High Court in the Central Region declared the 2020 general elections, parliamentary elections within the Asin North constituency, null and void. Now, the ruling was given, the court was presided over by Justice Kwesi Boachi, and he upheld that the National Democratic Congress, their 2020 parliamentary candidate for the constituency, Joe Jachikwason, had breached the provisions of the Constitution with regard to dual citizenship. This has since given rise, of course, to other issues. More importantly, a conversation on dual citizenship and political office within Ghana. Now, James Jachikwason, who is the NDC MP for Asin North, whose election was annulled by the Cape Coast High Court, has, of course, since proceeded to file an appeal. He wants the appeals court to quash the ruling nullifying his election results. According to Kwason, he's saying that the court should also order the Electoral Commission not to conduct fresh elections in the constituency. He is claiming that that order by the High Court to the Electoral Commission lacks legal basis. The case, of course, is still in court. Now, to back this, there have since been other conversations branching out of this. We're going to be speaking with some very experienced and knowledgeable minds on Spotlight today. We are speaking with a legal practitioner, private legal practitioner, Professor Kweku Azar, and Christian Hasey Malm. He's also a lawyer. We'll be right back with a breakdown on this particular issue. Stay with us. Welcome back to Spotlight. Before we went on the break, I mentioned we are discussing citizenship with regards to political office within Ghana, dual citizenship specifically. If people who hold dual citizenship can still occupy political office in Ghana. This has been a conversation that goes back many, many years, has affected both major parties, the NDC and the NPP. And let me just establish the facts of the case as we have it presently. Now, in the case of the petitioner against the Asin North Member of Parliament, who we mentioned, the Cape Coast High Court had ruled asking him to step down, of course, and a fresh election be conducted within the constituency. Now, the case against him is that at the time of filing to contest the 2020 parliamentary elections, he had not renounced his Canadian citizenship, and so he held dual nationality, to be precise. Now, the petitioner further states that at the close of nominations on the 9th of October, the Asin North Member of Parliament had still not renounced his Canadian nationality. He also says the Asin North MP, who still holds himself as the MP, is doing so in complete violation of Article 94(2)(a) of the Constitution of Ghana. Now, the judge also further stated that these facts are not in doubt, and although on December 17, 2019, this is the information that the Asin North Member of Parliament had applied by then to renounce his Canadian citizenship. For whatever reason, the paperwork delayed to the point where he did not get his certificate early enough. Now, the judge in his ruling also says that between October 5th and 9th, the Asin North MP filed to contest the parliamentary elections that he had or he had not received his certificate yet. But we're going to be finding out further how these facts affect the present ruling from the court, and if the Member of Parliament for Asin North can still hold himself as MP. As of yesterday, he had made some interesting comments to his constituents. So we're going to be speaking with the legal minds who, of course, will delve into this and make us understand it better. I mentioned earlier that we are going to be speaking to Dr. Rashid Rahman. He's the Executive Director for the Africa Center for Parliamentary Affairs. He's going to be joining us on phone shortly. He's presently held up in a meeting, but he will be with us in a few minutes. There's also a private legal practitioner, Professor Kwekwaza, who has been weighing in on this socially, and he's joining us to explain further his position, and also lawyer Christian Hesse Malm. Gentlemen, good evening, and thank you for joining us on Spotlight.
Good evening.
Good evening.
Thank you so much, Prof, for making the time. Now, let me go to lawyer Christian Malm. And as of yesterday, the Asin North Member of Parliament did visit his constituency to assure his constituents that he was he's still their Member of Parliament. Is this in breach of any legalities?
Okay, all right. First and foremost, where the Court of Competent Jurisdiction delivers its judgment, whoever that judgment is against, or if I would mention as that, has 7 days automatic period of which that judgment is stayed. So to that extent, that person in the context of who we are talking about could still hold himself as that. Now, upon expiry of 7 days from the date of the judgment, the rules of court, he cannot hold himself as that unless he proceeds to file what we call in court a stay of execution, so that whatever the consequential orders of the court, albeit in the judgment of the third court, then the stay of execution would stay whatever the judgment is, for him to continue with his duties until the appeal is dealt with. As I speak to you now, I am not apprised with, in my mind, whether or not the said MP or his lawyers have duly filed that particular process. But what I do know is that they have filed a notice of appeal. And from our body of jurisprudence in civil procedure, notice of appeal does not constitute a stay of execution. And I don't know upon what constituent of advice that he still maintains that he is still what he is. But as far as the judgment is concerned, and my submission that the period of the automatic stay of execution of the 7 days has lapsed, he cannot say that he still is unless he has filed the necessary processes.
But we are still within the 7 days anyway.
Okay. Then that holds it until the expiry of it. Just as I said, until the expiry, then he could still say that he is what he is.
Let me go to Prof. Prof. Now, you have not been entirely in complete agreement with the ruling of the court. Is it possible to explain your position to us?
Yeah, no, yes, I'm not in agreement with the ruling of this court, but we would be running away from the big problem if the emphasis goes to what has happened in this court. Because frankly, the issue is much bigger than what has happened in this court and predates what happened in this court.
Okay.
It started in 2006 when President Kufuor attempted to appoint Akwesi Prempeh from New Jersey as the Deputy Ashanti Regional Minister, and he was disqualified because, as it turned out, he was also a citizen of the United States. And then in 2008, Adamu Sankadi, honorable member of Boko East or Central, I can't remember now, he was elected, and a suit was brought along the same lines as we have happening in Asinov. And the judge indeed found that in that case, the judge actually found that he was not even a Ghanaian, a very strange finding, and he was removed from parliament. And again, I had difficulties with the Adamu case, I had difficulties with the Prempeh case, and naturally, I also have difficulty with this Asinov case. The problem we have is that we have Article 94(2)A in our Constitution. Article 94(2)A talks about exclusive allegiance. And without that exclusive allegiance, it disqualifies persons from holding several positions. We can talk about those positions because talking about those positions show the breadth and scope of the exclusions and why, upon a reasonable conceptualization of citizenship, that whole architecture must fall. But that exclusive allegiance was borrowed from ancient times, 500 years ago, when people could hardly travel, and if they did with a steamer, and where people's views of a filing system was limited to cabinets. So you couldn't conceptualize that a file could exist in multiple places. You put a file in one cabinet and it stays there. That thinking informed citizenship, and citizenship was considered as something that was exclusive and territorial. It only could exist within one territory, and it was exclusive territory.
So you are saying this is built on outmoded reasoning?
Yeah, it made sense in those days because people were not mobile. And if you were a citizen of United Kingdom, you could hardly go anywhere.
Yeah, okay.
Over the years, that conception of citizenship has changed dramatically from one where people viewed it initially as elective. People could elect what citizenship they wanted to, but still exclusive, to what we have today where citizenship is almost like a commodity. You can pay $1 million to become a citizen of another country. Citizenship these days is more strategic. So if you look at the world, by 1990, only 20% of the countries in the world allowed dual citizenship. Today, about 80% of the countries allow dual citizenship. If you understand this setup, then you would see that in our constitution, originally, like the rest of the world, we did not allow dual citizenship. If you go to the 1992 Constitution, Article 8(1) is of the form, any Ghanaian who acquires the citizenship of another country automatically loses his Ghanaian citizenship. And then there was this allegiance article in Article 94(2)A. It was then supposed to apply to very limited set of people because dual citizenship was not even allowed. What we have is that we have joined the global norms by allowing dual citizenship, but we have retained this allegiance language, and therefore we have a situation where you have citizens who cannot belong to parliament. Now, if you go back to the ancient Greece, Aristotle, he defined a citizen as someone who can participate in deliberative and judicial conversations. The African Charter basically says a citizen is someone who can freely, openly, and equally participate in the political space. On a closer reading of Article 94(2)(a), and if we accept that dual citizens cannot hold office, because that's what people are saying Article 94(2)(a) means, then what we are also saying is you are a citizen of Ghana, full citizen of Ghana, because a citizen of Ghana is a citizen of Ghana. There's no such thing as a fractional citizen of Ghana. You are a citizen of Ghana, but you cannot belong to the parliament. You cannot belong to the executive, because you cannot be a minister, you cannot be a deputy minister, you cannot be a secretary of the cabinet, and so on. You cannot be an ambassador. You cannot belong to any constitutional commission. You cannot belong to the Electoral Commission, Public Service Commission, Lands Commission, and so on and so forth. You cannot sit on the apex court of the country. You cannot form a political party. You cannot be the leader of a political party. You cannot be an executive member of a political party. You cannot belong to the high-ups of the security system, security services. You cannot even be a chief fire officer. You cannot be a special prosecutor. At that point, one should ask, why do you even call such a person a citizen of your country? If you
but
are
Prof,
so...
not to interrupt you, but are these limitations, there seem to be quite a number of limitations, how do they serve Ghana?
They don't, because that's what I'm saying. The problem is we are using a 500-year-old language that should have been eliminated from the Constitution at the time that we allow citizens to hold the citizenship of another country. And we are having this conundrum because basically you have a fractional citizen, a citizen who is almost worse than the type of citizens that we used to have under the apartheid regime, because even they had more rights than dual citizens. It's almost punishing a citizen who lawfully acquires the citizenship of another country. The law allows you to acquire the citizenship of another country, but when you do that, that same law, they are saying, takes away from you the fundamental rights, the universal rights of citizenship. Either we are not interpreting Article 94(2)(a) correctly, which is what I think is happening, or we should go back to the old system where we didn't even allow dual citizenship, or what I prefer is to amend the Constitution to remove these restrictions. And I'm glad there's a bill in Parliament to amend the Constitution, and we need to be talking about that bill to remove at. Yes.
Yes. Let me just come back to you in a moment. I'm just going to read a few highlights about that amendment. And let me bring in Lawyer Malm also. Let me get his comments on the conceptualization of Article 94(2)(a) with regard to citizenship. Now, the bill Professor Azar just mentioned, it has gone through its first gazette. Now, the bill, I should mention, it seeks to lift restrictions on the ability of dual citizens to hold some top positions in the country. If you listen to Professor Azar earlier, he did enumerate some of the restrictions. It's also a private member's bill that's being championed by the Akim Swedru Member of Parliament. Now, this constitutional amendment is aimed at lifting restrictions on dual citizenship from holding certain positions. And the bill is expected to go through a second gazette in at least 10 days after the first reading of the bill, which will be done by Parliament. Now, the bill is presently named Citizenship Amendment Bill 2021. And the preamble captures its main objectives as follows. One, the objective of the bill is to amend the Constitution of the Republic of Ghana to remove restrictions imposed on dual citizens. This is very, like, these are the cusp of the whole issue. Also of Article 8 and Paragraph A of Clause 2 of Article 94, and provide for related matters. Now, both, amending the statutes follows a slightly different path and only requires a simple majority of votes in Parliament. But we do not know that yet at this point, whether it will completely go through or how long it will take. But what's of importance is that it has gone through its first gazetting. Let me just go to Lawyer Malm. If you're still on the line, can you hear me?
Yes, I can hear you.
Yes, I just wanted your comments on the conceptualization of citizenship with regards to Article 94(2)A from your angle, before we get into the bill itself.
If you are looking at the conceptualization, what exactly are you looking at in this place?
Earlier, Professor Azar mentioned that this was, something, an outmoded reasoning behind the whole conceptualization. What do you make of it?
You see, for some of us, we stand so step foot in the legal theory, or what we call the pure theory, or the jurisprudential theory of law. And in that, it's embedded in what we call the Hans Kelsen theory of law. Now, it is important to know that until a repeal and amendment has been made, the grand norm is what suffices. And that has been our position. Now, what is or what ought to be is not our major concern, because whether you are a natural lawyer or a positivist, the grand norm in law or in legal theory is what suffices for us. And until, just as I said, there has been a repeal or any other situation, what remains is what remains. Primarily because the whole jurisprudence behind this particular law is the sovereignty of the state. Now, if you further read law into international law, you realize that what it is deemed as sovereignty of the state becomes paradox at a certain point in time. So that at this particular point in time, the jurisprudence behind the constitutional provisions is that the sovereignty of the state remains at all times the primus ultimus. So that if you have a dual citizen of another country who holds a certain sensitive position in state of position, then the position is that that person ought to weigh that particular position in order to owe allegiance to the state of Ghana. Now, I understand and I get wherever he's coming from, whether it is archaic, it is all of that. But any person who is so adherent to pure theory of law would tell you that the position of law is that until it is repealed, until the people amend it through Article 11, because law emanates from the people, then that rightly remains the law of the people, because they want to deem their sovereignty as what it is and not what it ought to be. So that if, given what other people are doing with respect to progression in modernity, it beholds on the people of Ghana through Parliament to see it fit to repeal or amend such provisions and reflect the thinking of my colleague friend, Professor.
So would you say what is being done now is the right step, because we know it's...
I as a naturalist would deem it as that. and also ascribing to the pure legal theory of Hans Kelsen, the learned doctorate jurist of law in jurisprudence. I would ascribe to it until Parliament, albeit the people of Ghana, has amended it through Article 11, because law emanates from the people. The customs and traditions of the people is deemed through Article 11. Then I have no option. But as the law is now, it is the grand norm of the land. And as the grand norm of the land, whatever research or thinking or legal writing that you are seeking to do from it, you should eventuate and see what the legal theory is behind it. And like I said, the legal theory behind it is sovereignty. So as to whether you stand for sovereignty or against sovereignty, in the light of such sensitive position, one's opinion is very respected, and I respect his opinion. But the law remains the same, and until Parliament amends or repeals it, it is what I stand by.
Lawyer Mam,
in the light of jurisprudence.
Let me ask you a question which directly relates to the Asin North case specifically. Now, there's been a bit of argument surrounding whether the date of renunciation or the date of receipt of the certificate is more important than, which of it is more important than the other here?
Yes, I have argued severally on other platforms and said that for me, as a progressive thinker, and also on or thinking in the light of law, the position of the judge is not wrong, because he came from the strictest application of the law. And that strictest application of the law is hinged on the old century or 17th century case of what we call the rule in Milroy and Law, which says that equity will not perfect a case.
Right.
So that where the MP failed or where the MP exhausted all legal obligations in order to perfect the certification, albeit from the third-party institution, at a certain point in time, it became beyond his effort. And by the position of the court, where he has exhausted all means, and his intention became very express through statutory declarations and all of that, albeit he not getting his certificate, the position of the court is that he is still not legitimate. And that is the position in Milroy and Lord, even though the judge did not mention that in his submission.
Right. Should it have been considered though?
Moving forward,
because
there's a second leg to it, if I may.
Please, yes, do.
But moving forward, the position of the Lord developed beyond this position, beyond what I just stated, and being the position of the learned judge.
Right.
But there came an exception, and that exception only exists not in law but in equity, and equity follows the law. And in that position, or exception to the Milroy case, is that equity will perfect an imperfection where the victim, in this case the MP, has carried out with his legal and statutory obligation, albeit in the context of renouncing his citizenship, his dual citizenship, to the Canadian country. And all the statutory or administrative duties now were not born of him, but were born of a third country. And that third institution or third party institution did not carry out with whatever it is expected of or was expected to relay of the victim in the situation of the MP could not be held to be liable. And that is the exception. So I expected the court to go beyond the old tradition and delve into the exceptions and see how best the court was going to juxtapose the legal argument with respect to this. But the court didn't go into that. And when your people interviewed me, I told them that this matter would definitely go for appeal.
Okay.
And I am not surprised.
Which is what we see happening now.
That it has gone to appeal. Because that lacuna, just that I have explained now, with respect to the legal positions and the legal theory that I have also espoused already, would come in place when the Court of Appeal is dissenting on this matter.
Well understood, Lawyer Christian Malm Hersey. Thank you for those points there. Let me just go back to Professor Azar, who was just beginning to comment on the bill for amendment. Prof.
Well, you know, my good friend makes a lot of interesting submissions about positive law and natural law and so on. And I really did not want to get into a whole lot of that because, you know, number one, if we are going to talk about law, then let's talk about law. When Article 94(2)(a) talks about allegiance and Article 8(2) talks about dual citizenship, we cannot equate the two, as my good friend is doing and as the judge is doing. It is trite law that when the person who writes a law chooses different language, then he has different intention behind those different language that he has chosen. There's a person who owes allegiance to a country other than Ghana. We have to figure out, well, exactly what does that mean? And if it means a person who has the citizenship of another country, then why didn't the lawmakers say that? Would it even make sense if in the original constitution, dual citizenship was not allowed for Article 94(2)(a) to have been addressed to dual citizens? I mean, so this whole allegiance and so on, sovereignty, positive, it's more complicated than that. We are dealing with constitutional matters. Equity maxims cannot be invoked to interpret the Constitution. We need to, if we want to understand allegiance, go to an old English case called Calvin case. It was an old case, and I don't want to get into all that because now we have to come and distinguish between natural allegiance and local allegiance and perpetual allegiance and permanent allegiance. It gets very, very messy. Suffice it to say that allegiance is not the same thing as citizenship. This is very, very, very known to anyone who knows a little bit about citizenship and allegiance. For instance, there's a case in Philippines on point. If you look at the Australian Constitution, it has a person who is either a dual citizen or owe allegiance to another country. The same thing is true of the Nigeria Constitution. So first things first, allegiance is not the same thing as dual citizenship. Second, you raise an important question. Supposing we accept that allegiance is citizenship, which is not true, then when does renunciation when does renunciation become effective? And here we need to be distinguishing between two things. Renunciation of citizenship, which the Canadians control, and renunciation of allegiance, which the person controls, because it is the person who owes that allegiance. So if I owe you allegiance and I say from now on, I don't want to deal with you again, I'm gone, and you say, well, I'm going to take my time to decide when to renounce your citizenship. And as a result of my taking my time to renounce as a result of taking my time to decide when to renounce your citizenship, you are permanently owing allegiance to me. It will be irrational. The easiest way to understand that, and it may be very primitive, is to think about a marriage.
Right.
And one of the parties want a divorce. and you file your divorce papers, the divorce is not effective until the court has issued the divorce decree. But on that very day that you filed your papers, any affection, any allegiance that you had to that spouse is gone.
Prof, but you can't call yourself a single person yet until the court comes through.
That's what I'm saying. You can't call yourself a single person, but we are not talking about your status. We are talking about your affection, your allegiance. That's why I'm saying you need to distinguish allegiance
from
which
citizenship.
Is something a person owes, from citizenship, which is a status. The status, the Canadians control when you can become a citizen and when you are no longer a citizen. But they don't control when you owe allegiance to them.
Prof, but which one holds supreme?
And that's why in Canada, as soon as you apply to renounce your citizenship, they make you move out of the country. Okay? So you have to actually be out of the country before you can even apply. And so this person who applied in December 29, 2019, has been living in Ghana since then. Now, that is a second aspect. The third aspect, when you go to PNDC Law 284, it is abundantly clear that it makes a distinction between when a person is qualified to be nominated as a candidate versus when a person is qualified to be an MP. When it comes to voter registration and your age and so on, those things are tested at the time that you are filing your nomination, because that is PNDC Law 284, Section 9.1. When you go to Section 9.2, which deals with this topic of allegiance, which I think most people don't understand, it talks about the test being made at the time when you are becoming an MP, qualified to be an MP. They make a distinction between qualified to be an MP and qualified to present your nomination papers, which the conversation here seems oblivious of, and which the judge's opinion also seems oblivious of. And then there's even a third thing that is important. In this country and in most countries, elections are not voided on very administrative grounds, that some bureaucrat in Canada hasn't processed someone's papers quickly. Therefore, we are going to set aside the wishes of some constituents in Ghana. That's something that a judge should do rather slowly. And that is why if you look at Section 20 of the PNDC Law 284, it talks about when you can void an election. And when you look at when you can void an election, it relates to when the person is going to Parliament, not when he files his nomination. So on any grounds, the distinction between allegiance and citizenship, if you assume that citizenship is allegiance, when renunciation becomes effective, all of those grounds would be good reasons why basically this thing on appeal will not stand.
Prof,
but like I said, yes,
let me ask you an interesting question in direct relation to this. Now, if we're talking about, when you file to renounce, and between the filing, renouncing your allegiance and waiting for the certificate to come through, the direct opposite, if you choose to become a citizen of a country and you file your application, you cannot exactly call yourself a citizen until the papers come through making you a citizen.
Absolutely. That's what I said, that when it comes to when you are a citizen or when you are not a citizen, Canada controls that.
Okay.
When it comes to whether you owe allegiance or not, Canada cannot force me to owe allegiance to them. Okay. The only country that can really force you to owe allegiance to them is the country that you were born in. That is natural allegiance. The natural allegiance, whenever you were born, you owed it, and you owed it for life. But if I migrate, there are some countries where once you even get their citizenship, you are no longer able to renounce it, even if you don't want it. They say we don't allow renunciation. Does it mean that you are forever
tied to that
indebted to them and owe allegiance to them. Of course not. That is a very perverse reading of the meaning of renunciation. But the difficulty people are having is because they are not able to separate allegiance from citizenship. Citizenship is a status. You have the status of being a Ghanaian. It doesn't mean you owe allegiance to Ghana. And let me land on one last point. If you read a case in Ghana called Bilson versus Rawlings, Rawlings made an affidavit, and in his affidavit, he said he was born in 1947.
In Ghana.
When he was born, he was a British subject, and because of the UK Nationality Act Section 3, he became a UK citizen. And then in May 1957, when Ghana passed its first Nationality Act, he also became a Ghanaian. In court, Rawlings admitted that he is both a Ghanaian citizen and a UK citizen. And many people who lived around that time were both Ghanaian citizens and UK citizens, because the Ghanaian citizen did not even exist until May 1957. Nevertheless, the judge in a hypothetical, he said, even if we assume that Rawlings is both a citizen of UK and Ghana, it doesn't mean he owes allegiance to a country other than Ghana, because he had served in the army for many years, and during those years, he had taken multiple allegiance to Ghana. And that suffices to convince the judge that his allegiance is to Ghana, regardless of whether he has citizenship of another country or not.
Thank you,
so
Prof. Thank you, Prof. I'll come back to you shortly. We've just been joined by Dr. Rashid Draman, who is the Executive Director at the Africa Center for Parliamentary Affairs. I'm going to bring him into the conversation. So Prof will continue shortly. Also, lawyer Maum Hesi. Dr. Rashid.
Yes.
Good afternoon. Good afternoon. Thank you so much for joining us on Spotlight. We're grateful for your time. Quick question. We've been discussing citizenship and allegiance. I'm sure you have heard some amount of that discussion. What is your angle?
No, I think I agree. Completely with the position of the learned professor. I think I was on your platform a few weeks ago, and then some other platforms, and I have been saying all the time that this is a very bad law. Without going into the specific, because I'm not a lawyer, for me, I just stand on a layman's kind of point of view. That look, on the one hand, without the contribution of our diaspora, when it comes to the economic contribution and so on, and then in another breath, we say these are people who cannot contribute to the political process in our country. So for me, since Sakande's issue, I've always said that if there was only one law that I wanted to change in our constitution, that would be that law. And the other day,
it's been
enjoy news, and I heard the professor, he had a list of all the kind of positions in our country that you cannot hold just because you hold the citizenship
of another country.
There's a very important point that he made about the bureaucratic processes and procedures, and I was thinking that look, sometimes in applying the law, I believe there has to be some common sense in terms of looking at the situation. I personally had relations who were caught up in a similar thing like the honorable member of parliament, albeit they were not running for office. They applied for Canadian documents, and then that was just around when the COVID in March of 2020. And then normally the Canadian government says it takes 45 days for the person to get all the things regularized, maximum 45 days. And then after COVID, on the website of the immigration in Canada, they said now it takes about 120 days because they are working on the
much longer
emergency and people are not there and so on. And I thought that, in applying the law, in examining this person's case, all these matters would have been, taken into account because really, I mean, it's not his fault that the renunciation certificate did not come, in good time.
Dr.
At least he
Draman,
had good intent.
from the parliamentary angle, what happens to
Yes.
the matters in which the Asin North Member of Parliament has already voted in Parliament, especially now that he's heading to court to appeal? What happens in the meantime? As we know that one of the big issues in which he has voted is the election of Speaker of Parliament. Are these areas affected in any way?
Well, I mean, I don't know whether, I haven't read the judgment. I don't know whether the judgment takes retrospective effect. Maybe the lawyer can say that if it does take retrospective effect, I don't know what that means. But I know what is on everybody's mind is, the election of the right honorable speaker, because on that day he made a very big spectacle in Parliament, and that was what led to all the drama that occurred between the night of January 6th and the morning of January 7th. I mean, having said that, if we have to, remove the speaker, I know Parliament needs about 2/3 of the majority to remove the speaker. I mean, is this possible?
Yeah.
Would this say, assuming that they say his vote had no effect, I mean, would it change anything? Can all this be done? I don't know.
Now, okay, let me just bring in Lawyer Malm Hesse to answer that part. Lawyer Malm.
Yes.
Yes, so what happens in the meantime? What do you think? What happens to the issues in which he has participated as a member of Parliament?
Well, I mean, if the judgment does not nullify retrospectively whatever he has done, they stay still progressive. But the major concerns that I take to address, I appreciate Doc. I have been on other platforms with him, and this matter has come up. The common sense approach, just as he mentioned, has always survived in the discourse of law. And the common sense approach in law is what we call equity. The hard sense of the law is what we call the law simpliciter, or proper so-called, in legal jurisprudence. And the common sense approach in law, we say, is equity, and equity follows the law. So that on a couple of platforms that I have been, where Doc has also been, I have spent some time trying to explain to the general public that the dicey situation of law that exists is that the renunciation of the MP's citizenship to Canada and he getting his certificate, there are 2 point coordinates. Now, the gap that exists between when he got his certificate and the interval is very significant for legal pronunciation. In that, the gap is that when he carried out everything within his legal mandate, feel that every statutory thing expressed his intention, of which the third-party institution was then to follow up with the necessary renunciation certificate. Came what we know as COVID-19. Now, in our jurisprudence, we have what we call judicial notice. The court, again, I expected that would have delved or analyzed a bit of it, because this case should have dealt on its merit. So that in dealing with the exceptions in the Milroy and Lord case that I already mentioned, which was the position of the court in coming to its conclusion that where there is no certificate, before judgment, before filing nomination, then it is simpliciter. But if you move into the exception, then it would mean the common sense that I am saying, which is equity, which it is a basic concern for for drug saying. So that if the court had gone beyond and dealt on the submissions that I have done, then it would have satisfied Doc's mind and the general public's mind on the position of equity perfecting gifts. And there we would have known how the court would have taken in consideration issues relating to judicial notice of the COVID-19, because we were in unusual situation, and for that matter, you cannot visit the scenes of the third-party institution to the victim, who is the MP. Now, especially when the MP had carried out everything necessary, and the statutory time for him to have gotten his certificate would have been predicated on, or being a precedent for him going into the election. So he would have gotten it before going for his nominations and all of that. But because of the COVID-19
delays,
it culminated in delay. And the court should have taken a judicial notice. The court should have addressed us on issues of the exception with the Milroy situation. And these are serious issues in law. It does not lie with normal lay arguments.
Lawyer Mom, do you think he has a strong appeal case?
Yes, he has a strong appeal case. And I'm looking at how the Court of Appeal, immediately the decision came out, this has been my submission. And Doc will bear me out. We'll enjoy news or so. And this has been my position. And thereafter, the appeal came, the notice of appeal came, and I was not surprised. And if the Court of Appeal does not deal with it well, I am hopeful that we'll see it at the Supreme Court. So that the court, and mostly with this election matters, it ends at the Court of Appeal. So the contention of the court would now deal with the fact that will it be for the exceptions to lie, that where one exhausts all statutory matters to renounce, and the third party delays or does everything to delay, would be enough to say that the victim, be it the MP, has not exhausted or discharged whatever legal obligation is of it, or equity would come in to perfect his gift. Because even in wills, let me digress a bit, in wills of a testator who is on his deathbed and having carried out transfer of shares, or in carrying out the device of his will, and having done everything within his legal mandate to execute the transfer of shares, and it is within the hands of a third party to complete such execution, the court comes in as a matter of equity in this exception that I am arguing out to perfect that imperfect gift, to hold the testator's intention. And this is not new to law. That is why I think that at the Court of Appeal, the learned justices will come up with interesting dissenting opinions on this matter. And it will shape the jurisprudence of the law.
Thank you, Lawyer Malm. Let me just go to Prof, who initially was commenting on the first gazetting of the bill. Prof, if you could just come in. Prof, are you still with us?
Yeah.
Yes, you were.
I don't think whatever. Should I come in?
Please do, yeah.
The delay in Canada is actually inconsequential, because if the judge had read PNDC Law 284, all of these discussions would have been moot. The PNDC 284 clearly says, and I'm going to read it because I just got it. I cited it first without reading it. 20D basically says the election of a candidate shall be declared void on an election petition if the High Court is satisfied that the candidate was at the time of his election on December 7th, that's when he was elected, a person not qualified or a person disqualified for election. So as long as the renunciation certificate came in before that date, then he was qualified and he could not have been, the election could not have been voided. So that settles this matter. Right. I want to make another point.
Please do.
That this other citizenships, we must be very, very careful when we tread that way. In the early part of our history, several members of the then Muslim Youth Association, Balogun, Wahab, and so on, they were Ghanaians, but they were deported under the Deportation Act because of their other citizenship. It is not only in Ghana. Sometimes it leads to conflict. People don't realize that the conflict in Ivory Coast arose because people claim Ouattara was from Burkinabe. And because he was from Burkinabe, as well as from Ivory Coast, they wanted to disqualify him. It even gets very ridiculous if you go to a place like Zambia, where Kenneth Kaunda led the country to independence. In 1996, people claimed his parents came from Malawi, and so they wanted to disqualify him from holding elections, from running for elections or president. The same thing happened in Nigeria. The guy's name is Alhaji Shugaba. He was deported. In Botswana, the same thing has happened there. My biggest fear is that this other citizenship-based exclusionary tactics, it has the potential of fueling broader xenophobic sentiments. People start taking on dual citizens and diasporans. They look at them funny. You people are serving two masters. You people are not real Ghanaians. Some kind of xenophobic sentiments. We really need to be cautious. It also legitimizes other exclusionary nation-building strategies. Ghana is a country that needs all our hands. We shouldn't be excluding anyone who has an ounce of Ghanaian blood in him. It widens social cleavages at a time when we don't need such cleavages. In my mind, it reduces the likelihood of democratic consolidation when we need more consolidation rather than less. And this is my biggest fear, that it plants the seeds for future political conflict and possibly even war. Because what you are doing is you are telling someone who is a citizen of Ghana that you, another citizen of Ghana, somehow you have more rights than him.
The person.
He cannot belong to parliament. He cannot belong to the executive. He cannot form a political party. He cannot lead a political party. In fact, in about
Prof,
3 or 4 years...
If you can wrap up in 1 minute, is that possible? We are running out of time.
NPP tried to export Article 94(2)A to their constitution. And if you read the constitution literally, they could do that, because Article 55 says that a person who owes allegiance to a country other than Ghana cannot be an executive member of a political party.
Okay.
Realize that if they apply that law, their diaspora branches will collapse immediately, and so they stopped. So my final point is, how can a law that we are applying in the national constitution not be put even in political parties' constitution, because they realize that they can't do it because they have people all over the world, and many of these people have allegiance to other countries. That is where I want to end my submission, that we need to be a little more careful when we
with the
exclude
application.
other Ghanaians from the political space.
Thank you so much, Professor Kwekwaza. He's a private legal practitioner. Lawyer Mamhesi, if you can just wrap up in 1 minute for us. Sorry, Dr. Rashid Draman.
No, I think I just want to agree with the submissions of the prof. I'm actually sitting and talking to you. I'm in Burkina Faso at the moment,
Right?
And some of what he said, I mean, rings a lot of bell. I mean, for instance, the challenges in La Côte d'Ivoire, and so if we are not careful, someday somebody would emerge as a leading light for a political position, and because maybe some opponents see him as a threat, we can conjure this, and we don't want our path to resemble the path of La Côte d'Ivoire or some other countries that have fallen in similar traps. I mean, like he rightly said, at this moment, we have so many problems in our country. Every contribution counts,
Yeah.
and we should rather be bringing people on board rather than trying to exclude people from our political process.
Thank you so much, Dr. Rashid Draman. He's Executive Director of the African Center for Parliamentary Affairs. Let me just go to Lawyer Christian Mamhesi to give us his closing remarks in 1 minute, please.
Yes, I appreciate the opinions of the panelists, and my basic submission is that the fundamental position of the law is what it is, and as an astute naturalist of the law in the sense of natural jurisprudence, until the law is amended, it remains what it remains, and it behoves on Parliament to amend or repeal under Chapter 25 of constitutional provision. Anything less of it, the law remains what it is.
Right.
And others need to follow it.
Yeah, we know that the amendment is presently ongoing. We'll be following closely to see the updates on that. And, of course, we'll be reporting them right here on MX24 television. We'll also be following the appeal process and letting you know exactly how it turns out. But thank you for spending your 1 hour of your evening with us on Spotlight. We hope that you've learned something, as we have. And on behalf of the entire production team, we are grateful for your time. See you again next week, same time. Good evening.